I know a little bit about the intellectual property rights, especially patents. And so, with that background, I thought I can talk to you regarding the intellectual property rights because maybe your students are doing so many projects, especially final years you'll be doing. And these projects, if they are worth enough, you can file a patent, right? That will be very helpful to you. Then, if it is the case, then what are all the steps involved and which can be patented, which cannot be patented? All these informations I thought I can share with you. So that is the idea behind this topic. So with this brief introduction, I'm just moving on to the topic intellectual property rights, okay, IPR. Right. So what is IPR? Intellectual property is that which results from the creation of in the industrial, scientific, and literary and artistic field, a creation of an idea, a novel idea, a new idea which is not existing, or something which is better than the existing one. These ideas can be converted. These are called as intellectual property. Because why this is called as intellectual property? It comes from your brain, right? You are creating a person, particular person. His intellect is creating that product. So that is why it is called as intellectual property rights. The property rights are exclusive rights granted to that particular person so that it is not copied or overtaken by others, right, for commercial applications. So that commercial exploitation can be avoided, right? So the IPOs can be assigned or licensed for financial benefits also, right? So suppose you are developing a patent, right? You are developing a product and getting it patented means then you yourself can manufacture that product, or you can give license to somebody else for which you can earn the royalty. So financial benefits are much there. So that is also assured by this IPR, okay? So when we talk about IPR, there are three categories under it. One is a patent, which I am going to concentrate now. The other two things are copyright and geographical indications. So first, I'll briefly tell about what is copyright and what is geographical indications, and then I'll come back to patent so that we'll see in detail. I already told you I'm going to focus only on patent, not on copyright or geographical indications. Just what is what I'll tell you about copyright and geographical indications. Copyright you might have already heard, right? Somebody is writing authoring a book, then he owns the ownership of that article, right? So he will be doing it as making a copyright of that article. So without his permission, we cannot reproduce or copy that writings. In the textbooks itself, you might have seen C, a symbol in the top of the left corner of the page, C, copyrighted. That symbol you might have seen. That means that is being copyrighted by a particular person. So this is artistic works, dramatic, literary, dramatic, musical work, etc. All these things can be copyrighted. These cannot be patented, but these can be copyrighted. Example, in computer science, all the softwares, right, can also be, suppose you have a software for any particular application, that can be copyrighted and that cannot be patented, right? If it is clubbed with hardware, then it can be patented, okay? Right. So a copyright protects a particular manner in which the work's content ideas are expressed. So his own idea is expressing in a particular book. So that is being protected. Nobody else can copy that. So it is a bundle of rights, including rights of reproduction, right, communication to the public, adaptation, and translation of the work. Even if you are going to translate from one language to the other, what he has written, the copyrighted or the written, then that also it needs permission. Okay. So similarly, in that case, ideas, facts, slogans cannot be copyrighted. Simply ideas or facts that are existing and slogans. Many companies are using very, very different slogans. These cannot be copyrighted. Okay. Right. Then what is geographical indication? A geographical indication, it identifies goods, either agricultural, natural, or manufactured, right, in a particular area. It is identified with a particular area. For example, in Tamil Nadu, Kanjipuram silk, that has a geographical GI tag, we call GI tag. Kanjipuram silk, Arani silk, Madurai Sungadi saris, and then recently, if I'm correct, if my memory is right, Srivilliputtur Palkova, that also has got GI tag. So this is like a manufacture the product, particular thing manufactured in a particular territory of a country or a region. So when a given quality, reputation, other characteristics of the such goods essentially attribute to the geographical origin. So that particular quality that cannot be done in other places. So then we are giving that geographical index that is to a particular product. For example, I already told you right? Kanjipuram silk, or even Coimbatore wet grinders, right? That is also having a GI tag. Okay, right. Now I come to our topic. The first one, the patent, right? What is patenting? Who can file a patent? Where to file a patent? And how to file a patent? All these things we will see one by one. Okay. So we can, for any clarifications, I have given the website address also, ipindia.nic.in. If you go into that website, all details are available. But I have simplified these data and I am giving to you. Right. So what is the importance of patents? So it is a patent is an important source of scientific and technical literature. Right? It's a treasure house of scientific inventions. Most of the inventions are uh, patented. So it's a treasure house of scientific inventions. It avoids duplication. If it is already patented, means nobody else can duplicate that idea or that product. Okay, then it paves way for further discoveries. We can improve upon that. Only thing is you cannot duplicate or you cannot copy, but you can improve the system already, which has been patented. Further discoveries can be made over that. Okay, so it is stop reinventing on the wheel. What does it mean? So something which is already existing. If you come to know about it, then you need not spend time once again and reproducing it. So it stop reinventing the wheel. Identifies emerging technologies and emerging areas, right? So these are the importance of patents. So what is a patent now? So it's a statutory right to the inventor or applicant by the government that is invention, which is either a new process or product. You are discovering a product, you are inventing a product, right? Then it belongs to you. That right is given by the government to you. That is what is called as a patent. It's a statutory right. You have all the statutory rights over that product. So it's a limited period of time. It is valid for a particular period of time. For example, I can tell you in the case of medicines, so many pharmaceutical companies are manufacturing medicines, right, for curing particular disease. For example, I am telling these the diabetics patients, they are manufacturing so many medicines. For they have developed a new compound and they might have obtained a patent upon the Pfizer Indian, which is a chemical company. That company is manufacturing a particular drug. That means they alone can manufacture that particular drug for a period of time. So the patent will be normally granted for a period of 20 years, I say. It is different for different applications. I'll come to it later. For example, I am telling, so 20 years means after the 20 years, anybody can make, any pharmaceutical company can make that medicine freely. It can be distributed to the government. That is what is called as generic medicines. Now, if you buy generic medicines, right, so that will be very, very cheaper. It will be very, very cheaper. For example, in the government of India, they have run so many medical shops selling these generic medicines. For an example, if I am selling like paracetamol is a generic name and it is manufactured by different companies. For example, Crozin. Crozin is the name of the company manufacturing that paracetamol tablets. Is it not? So the generic name is paracetamol. For example, I am telling this patent means for particular disease, especially for the sugar and cancer, once the period is over, then these medicines will become cheaper because everybody will be manufacturing that particular medicine and it will be becoming cheaper. Okay. Right. Just for an example, I took the case of a medicine. Then it is a limited period of time. It is granted in lieu of sufficient disclosure to the patent office. You have to give sufficient disclosures. What are the disclosures you have to give? I'll tell you. So sufficient data if you are giving to the patent office. So it is a territorial right. For example, it can be valid in India alone, or if you want to make it as international, then you have to apply for an international patent. Okay. So that classification is there. So what are the criteria to get a product patented? It should be novel. Novel means it should be new. அது வரைக்கும் இல்லாதது, not known to public before filing. So it is an inventive step, a feature of an invention, right? You have technological advancement and invention, right? A particular person is doing means that can be converted into a patent. Industrial application, it is capable of being made or used in an industry. So these are all the criterion for patentability. The main thing is it is an invention which is not available already. It is a new thing. It is your brainchild. If that is the case, it can be patented. What are all non-patentable inventions? You should know which cannot be patented. Then you will understand which all the things you can apply for patent. Okay, so inventions that cannot be granted patent under Section 3 of Indian Patent Act 1970 are called non-patentable inventions. right? A few examples. I am not citing all these things, just a few things I am telling. Just important things alone, I am just highlighting. Okay. In section 3A, they say an invention that is frivolous or that claims anything obviously contrary to a well-established natural laws, right? So if it is so, you cannot make it as a patent, which is frivolous or it claims anything absolutely contrary to the well-established natural laws. For example, you are telling a machine is giving more than 100% efficiency. Is it possible? It can never be possible based on the natural laws. Is it not? It is not possible. So suppose you are making such a claim, then that cannot be patented. Then, for example, a perpetual machine. I hope you know what is a perpetual machine. Perpetual machine means it can run continuously without any energy source. Energy எதுவும் supply பண்ணாம அது continuous work பண்ணிக்கிட்டே இருக்கும். அப்படி எந்த மிஷினும் இல்லை. It is against the natural laws. So if you are making such a claim, such claims cannot be patented. Is it clear? Right. One more thing, section 3B, it says an invention, the primary or intended use of which would be contrary to the law or morality or injurious to public health. So if it is against the law of a particular country, right? If it is a law or a morality of that particular country or injurious to a public health means, then that idea cannot be patented. For example, one example is the onco mouse. It is genetically modified to develop cancer for the purpose of research. This is not patentable because cancer can be transmitted to the public. So in laboratories, the onco mouse, it is genetically modified to create cancer and then treat cancer. So this idea cannot be patented because the cancer can be transmitted to the public also. So that is one thing. Then section 3C, mere discovery of scientific principles. Mere discovery of scientific principles cannot be patented. For example, Newton's laws, right? Movement, discovery of microorganisms, right? Or discovering any living thing or mere discovery of scientific principle. This also cannot be patented. Okay. Then mere discovery of new property or new use for a known substance, right? So suppose you have discovered a new property of an existing material or product, then that cannot be patented. New use for a known substance. A substance is already there, but you are discovering a new use for it. Then that also cannot be patented. For example, aspirin, if I am right, it is used for healing headaches. Now they have discovered that it can be used for curing the blocks in the heart or heart ailments. So now that idea cannot be patented because aspirin is already there. It is already there. Only a new property it has been discovered. Similarly, neem, வேப்பலை, right? It is there already. We are using for different medical applications. நீங்க ஏதாவது புதுசா வேப்பையில தேய்ச்சா தலைவலி குணமாகும்னு நீங்க கண்டுபிடிச்சீங்கன்னா that cannot be patented. Okay, just for example. Then section 3E, a substance obtained by mere admixture resulting in aggregate of the properties of the components. ரெண்டு மூணு component mix பண்ணி already available components you are taking and mixing and creating a new component with new properties means, then that is also cannot be patented. For example, combiflam is a tablet which is a combination of two medicines. One is a paracetamol, another one is a brufen. இது ரெண்டையும் கலந்து கொடுத்தா தலைவலி காய்ச்சல் எல்லாத்துக்கும் அந்த மருந்து டேப்லெட் ஒர்க் ஆகும். இல்லை நீங்க தலைவலிக்கு தனியாக ஒரு மருந்து சாப்பிடுவீங்க, காய்ச்சலுக்கு தனியாக ஒரு மருந்து சாப்பிடுவீங்க, right? So it's a combination of these two. So this also cannot be patented. Then mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way, this also cannot be patented. You have two or three products or equipments you are combining or rearranging and then making it to do a different work means that also cannot be patented. For example, I have given a bucket with a torch. You have already a bucket, you have already a torch. Then if you make a bucket with a torch so that you can carry it at the night and fetch water, then that idea cannot be patented. An umbrella with a fan, you are carrying umbrella everywhere wherever you go. So during the sunny days, so you can fit a fan inside umbrella so that it can give you good air circulation. But fan is already there, umbrella is already there, just combining umbrella and fan, this cannot be patented. Is it okay? So another example is a clock and radio in a single cabinet, right? So these ideas cannot be patented. Then one more thing is method of agriculture or horticulture. Some methods for cultivation of some agriculture products These methods cannot be patented. For example, cultivation of algae, producing new form of a known plant, or preparation of an improved soil. These and all cannot be patented. I hope you have a brief idea about which cannot be patented. So idea has to be novel, right? It has to be new, right? It is not existing, that is not known to the public at that time, and that is not against law, right? Mainly. So it is not against the moral practices of the country. If all these cases are satisfied, then your product can be patented. Right. So what is the objective of granting a patent to a person who is applying for a patent? So it is a monetary reward for revealing technological innovations. So that's what I already told you. You have created a technological innovation, and then by getting an IPR, naturally, you'll be getting money out of it. So it is a monetary reward. Then to provide improved technology at affordable cost to public, right? So you are producing a technology, people, scientists are working or engineers are working, they are improving the technology available. When improved version is available to the public, means naturally the standard of living of the public also will rise. Okay, to facilitate technical advancement, naturally advancement in technology because of the invention of new products, and economic growth. When the technology improves, automatically the economy of a country also will rise. When the economy of the when economy is also will improve. At the same time, so many products will be coming into the market because of this IPR patent. So when the number of products are more, automatically the cost will be coming down and the higher life standards of the people will improve. So these are the various advantages or objectives of granting patent: to encourage commercial exploitation of the invention to its extent. So you're getting a patent, then commercially you can exploit. That's what I told you. You yourself can make it, or you can lease it to somebody else and you get the royalty. Oh, yeah, commercial exploitation. So what are the precautions you have to follow before filing a patent? Don't use invention in public for commercial use before grant of patent. Patent வர்றதுக்கு முன்னாடி you should not use that in public, right? That literature should not be published. It should not be known to anyone, because somebody is reading there, means then he will develop the idea out of that and he will object your application. So that danger is there always. So don't use the invention in public for commercial use. So it is advisable to file as soon as an idea gets a shape. If you get an idea to develop a product, means just with the idea itself you can apply for patent. Detailed procedures you can submit later. You can take a time of 12 months to submit the detailed idea. So that procedure also I'll tell you, right? So it is advisable, as soon as you get the idea, take a shape and then you file a patent. Then you can take 12 months time to complete all the design process. Okay, so once the idea strikes, apply with provisional specification. That's what I told you. With provisional specification, just idea itself you can apply for patent. With the 12 months you can complete, you can file complete specifications. Okay, then conduct novelty search, confirm an invention. Novelty search, you can search in the website for, suppose you are finding a product, any related material is already available or not, you have to search through all the websites. In the Indian patent website I told you, similarly the international patent website is also there. You can check whether such a work is going on anywhere, anybody has patented such a material. All these things you can make a novelty search and you can confirm your invention. Right. Now, what is the process of getting the patents? So I already told you, don't disclose your invention. Be curious, but do not disclose your invention. Keep it secret, right? So you keep I told you a bound notebook. You keep a record to prove when you get the idea, right? So you develop the idea and produce the model. Write your invention. Write why your invention is needed. What are the existing products in the market? What is your new product? How is it different from other products? Then what is the uniqueness of your products? All these things you make a write-up. To make a write-up. Okay. After that, we'll go for filing a patent. Okay. So do not disclose. Then keep a record of when you get the idea, how you develop the concept, what are the literature you have read, right? And then what are the searches you have made, what are the available, material related to your discovery. What are all the things available in the world, whether they have been patented or not, all those things you make a study and keep a record. Right, then there are three types of patents available. One is utility patent, another one is plant patent, and design patent. What is utility patent? New or useful process. It is useful. It can be a process. It can be a machine. It can be manufacturing process. It is the composition of materials or any new and useful improvement thereof. Right. That is what is utility in the utility side. Just a minute, please. Some poll is coming. Okay. Then design. Design, invention of new, original, and ornamental designs for manufactured products. Okay, new designs, original and improved designs, and then ornamental designs. These all comes under design. Then plant, any new variety of plant that can be reproduced asexually. That is important, right? Any new variety of plants that can be produced asexually, that can also be patent, comes under plant patents. Okay, so these are the three types. Right, then who can file a patent application? The application can be filed either alone or jointly. You yourself can file, or if your 3 or 4 members are doing a project and you have a novel idea, means you 4 can join together and file a patent. Okay, any person, it can be filed by any person who is claimed to be true or first inventor. The true inventor or first inventor, he can apply for patent. A patent can be applied to a person being assignee of a person claiming. Suppose you are inventing a product, right? On your behalf, you are asking your friend to file a patent. So that is assignee. You are assigning a person to file a patent. So he can also file a patent on behalf of you. The proof of assignment has to be submitted along with the application. Then by the legal representative, suppose you are running a company, right? Then they are going to file a patent, means they can find a legal person to file a patent. So legal representative, that is one thing. Suppose a person is deceased, somebody's friend or some relative is dead, but he has an idea. That idea can be patented through the legal representative of that particular person, right? So that also can be done. Then where to file a patent application form? The appropriate office of the patent office shall be the head office, patent office, or branch offices, as the case may be, within the territorial limits. What are the territorial limits? I will tell you in the coming slides, right? The residence of applicant or domicile. So where the place, suppose you are living in Tamil Nadu, means you are residing here. So you are going to file a patent, means Tamil Nadu comes under the Chennai patent office. So you can file a place patent there. Based on the place of business, suppose the business is running somewhere in India, suppose in Bombay, but he belongs to Tamil Nadu, but his business is going there in Bombay, means he can file a patent in Bombay also, right? The place where the invention actually originated. This is also, you are doing a research in a research laboratory in some part of India. In that place also, you can file a patent. You need not come to Tamil Nadu and then file a patent. In that place itself, you can file a patent. Okay, so if the application has no business or domicile in India, the address for in India is to be given by such applicant. Suppose the applicant is a foreigner who has no business and domicile in India, then for this address has to be given for filing a patent in India. Okay. Right. So this is the jurisdiction places. We have 4 offices: patent office branch Chennai, Mumbai branch, New Delhi branch, and the headquarters in Kolkata. So you can just look into the territorial jurisdiction. For Chennai office, people from Andhra, Karnataka, Kerala, Tamil Nadu, and Union Territory of Pondicherry and Lakshadweep, they can file. In Mumbai, Maharashtra, Gujarat, Madhya Pradesh, Goa, Chhattisgarh, Daman, and Dayu, Nagar, Haveli, all these union places, they can file. Similarly, in Delhi and in headquarters, Kolkata, in rest of India, they can file the patent. So this is the offices and their respective jurisdiction area. Okay. Right. Then now, how to file a patent? You can file through online, right? You can transfer, apply funds, fees can be paid online also. So through online, the website I have given, ipindiaonline.gov.in/online. If you log into that, you can file the patent, or you can get a printout of the application, fill it, attach with the DD, and you can send it by post also. You can do. Then you can go in person and you can submit. So when I say the fees and DD, what is the fees, you may ask me. Of course, I have not mentioned in the slide. Suppose you are an individual, you have in the final year, you have done a project, you are an individual, you are going to file a patent, means you have to pay a fees of 9,800 rupees, right? Fees you have to pay. Suppose an institution, a company or institution, suppose we are studying in Vivekananda College of Engineering, so not in VCU, you are going to, you have developed a product. Suppose you are filing a patent in the name of VCEW, then the fees to be paid will be 36,000. 36,000, right? I hope you understand. You are studying in VCEW. You are doing a project, you are going to, a new idea you have, and you are going to patent it. In two ways you can do. One thing, as an individual, you can file a patent, or you can make it a property of the VCU, and in the name of VCU, you can file a patent. If an individual, if you file, means the fees will be 9,600. For institution, if you are going to file, it is going to be 36,000. Just one example, I will take an institution. It can be industry also. Okay, then the fees will be 36,000. So this is a general procedure for obtaining a patent. First, you have to file a patent application. Then that patent application will be published in their patent journal within 18 months. Suppose you want to publish it yearly, means then you have to pay fees, and then it may be published within 2 months also. Right, then before a patent is granted, somebody may raise an objection. Journal, because the idea will be published in the journal. Anybody can look into the journal. It is available in the patent website, Indian Patent IP India. In that website, it is available. So anybody can log in and see that journal. So what ideas have been applied for patent? Then he may object, sir, this is my idea. Some reasons they may say they object. So that is what is called as pre-grant opposition. Remember, you have only filed. Patent has not been granted. Before granting the patent, somebody is opposing. That is pre-grant opposition. Okay, that may be there. Then you have to request for examination. Then the examiner will examine that, he may grant or refuse your idea. Then once if it is granted, it will be published in the journal. Once again, grant of patent. After granting also, post-grant opposition also may rise, right? In that case, decision will be taken by the controller. Is it clear? I hope you understand. First, you have to file, then it will be published within 18 months. And once it is published, then you can ask for examination. Then examination will be conducted, and the examiner will be submitting the report to the controller, and the controller will vet the report of the examiner, and then he will grant permission only when there is no opposition, right? Okay. In the detail also, I have given you. So these are the forms you have to submit. The form 1 is the legal information, your name, address, contact details, etc. Then form 2 is the background of your invention, summary of the inventions, the claims and all. You have to fill. In the form 3, the assignments, details of a foreign filing. So that is not needed for us. Then form 18, request for examination. Then form 9, request for early publication. This is what I told you. Once you file a patent, then for publishing in the journal, they may take 18 months time. Suppose you want it to be published earlier, then you have to make a request. Then form 26, power of authority. Suppose you are assigning the power to somebody else, then power of authority, that form also has to be given. Okay. Right. The documents required for filing a patent application. So naturally, a covering letter indicating the list of documents, then application for grant of patent in form 1, then form 2, then form 3, form 26 if needed. Power of attorney, if needed only you have to give. Then declaration of the inventorship, form 5, that has to be filled. Then request for examination, form 18. And then request to statutory fees. That's what I told you, 9,600 if it's an individual, 36,000 if it is an institution. So all these forms along with DD, you have to submit to the patent office. So what the essential ingredients of complete specifications of your idea? The title and preamble. right? Prior art means related to that product, what is the existing available, that is prior art. Drawbacks, existing method la enna drawbacks irukku, how you are going to overcome that. So efforts and solution for the drawbacks. Then the summary of your invention, statement of your invention, and detailed description of your invention, detailed description with reference to drawings, right? If needed, drawings to be made, and you have to make it. So this is the essential ingredients of your patent filing. So this is the process, right? So first, the conceptualizing, and so you have an idea, right? You have developed an idea. So what you are going to do, you are going to file an application. I already told you there are two ways. One, you have complete specifications are available, may be available with you, or you just developed an idea, you are going to complete it soon. In two ways also you can file a patent. Now first, I'll tell you the first process. Suppose you have only provisional specification, still you have to do a lot of work there. Even that case also you can apply for patent. So you can apply for patent. Then after filing the patent, within 12 months, what you have to do, you have to submit the complete specifications. If it is submitted, it will go to the next stage. If within 12 months, if you are not able to submit, means that application will be abandoned. That is one case. Okay. Now suppose you have all the complete specifications with you, you have developed the product completely idea wise, then you can file it, then it will be published. It will be within a period 18 months. It will take 18 months for them to publish in the journal. So that will be published. And then exam, is there any once it is published, you can go request for examination, right? Request for examination on form 18 within 48. Request for examination, and you are asking them to examine the originality of your product, whether it is working, whether it is a novel idea, right? All these things somebody has to examine. You are certified. So that is request for examination within 48 months from the date of priority. So you have applied, filed the patent. So அதுல இருந்து 48 monthsல you can request for examination. அப்படி ரிக்வெஸ்ட் பண்ணும்போது இஃப் தெர் இஸ் அ ப்ரீ கிராண்ட் அப்போசிஷன் எதுவும் இருக்காங்கிறத தே ஹேவ் டு செக். நான் ஏற்கனவே சொன்னேன், ஜேர்னல்ல பப்ளிஷ் ஆனதை பார்த்துட்டு யாராவது ஒருத்தர் அப்ஜெக்ட் பண்ணலாம். நோ திஸ் இஸ் மை ஐடியா, சம்படி examiners will examine your product, and then the first examination report will be given to the controller as well as to you. So first examination report, that is what is called FER, right? If first examination report la, he may, the examiner might have made some comments. இது சரியில்லை, அது சரியில்லை, அதை மாத்தணும், இது மாத்தணும், objections he might give you, right? So the controller offers the controller, what will he do? The controller patents, he will call you and ask your side. So this is the report of the examiner. What you are telling, can you modify this, or this is true or not? Then you can object that no, the controller examiner is wrong, my product is right. All these arguments you can do, right? So application is to be put in order within 12 months from the issue of the first examination report. Okay. And இப்போ அதுல இருந்து நீங்க அவர் எக்ஸாமினர் கொடுத்த அப்ஜெக்ஷன்ஸ் எல்லாத்தையும் மீட் அவுட் பண்ணிட்டீங்க, கொடுத்திருக்க அப்ஜெக்ஷன்ஸ் உங்களால ஓவர் கம் பண்ண முடியலன்னா, everything is okay, means within 12 months the patent will be granted. After granting the patent, post grant opposition may also arise. Somebody once again may object. In that case, the controller will take the appropriate decision. Okay, right? So this is how the patent is being obtained. File an application for patent with one of the officers, pay the required fees, then all the informations are available in the website ipindia.nic.in. The guidelines also are available in the website. Is it okay? The examiner, what the examiner will check also, I'll just briefly tell you in another 5 minutes and then we'll wind up. An examiner check the formal requirements before accepting the application and the fee. This is done immediately. இப்போ ஆஃபீஸ் போறீங்க, நீங்க இப்போ மெட்ராஸ் ஆஃபீஸில் போய் ஃபைல் பண்ண போறீங்கன்னா, இந்த எக்ஸாமினர் வில் செக் த ஃபார்மல் ரெக்யர்மெண்ட்ஸ் எல்லாம் ஆர்டர்ல இருக்கா, ஐடியாஸ் கரெக்டாக கொடுத்துருக்காங்களா, டிராயிங்ஸ் கரெக்டாக இருக்கா, ஆல் தீஸ் திங்ஸ் எல்லாம் செக் பண்ணிட்டு ஃபீஸ் இருக்கா எல்லாத்தையும் பார்த்து they will அக்செப்ட் பண்ணோன்னா they will give you application number and cash receipt on same day, right? Suppose நீங்க போஸ்ட்ல எது அனுப்பிச்சீங்கன்னா 2 to 3 daysல you will get the number. Then within the application will be kept secret for a period of 18 months from the date of filing. The 19th month, the application will be published in the official journal, right? Now the application has the option to get his application published before 18 early publications நீங்க out பண்ணி வாங்கலாம். அப்படி பண்ணீங்கன்னா 1 month of the request நீங்க ஒரு request கொடுத்த 1 monthல publish பண்ணுவாங்க, right? அதுக்கு separate fees உண்டு. After that, the application ஏற்கனவே உங்களுக்கு சொன்னதுதான். You can request for examination. The request for examination can be made either by the applicant or by the third party. The period of 48 months from the date of filing is available for making request for நீங்க இன்னைக்கு ஃபைல் பண்றீங்க, பேட்டர்ன் ஃபைல் பண்ணி இன்னையில இருந்து 48 months, that is 4 years டைம்க்குள்ள you can request for examination. Before that, you have to complete all your work, right? Complete நீங்க ப்ராடக்ட் டெவலப் பண்ணி அந்த ப்ராடக்ட் டெவலப் பண்ணி ரெடியா இருக்கணும் for examination. Okay, right? Then suppose you ask for examination, then the examiner will take 1 to 3 months to examine your product and submit the report. After that, the controller will take 1 month time to vet the examiner's report. Examiner's report la enna irukuna அவர் study பண்ணி to come to a conclusion, it may take 1 month's time. So the first information report containing the gist of objections within a period of 6 months, right? Suppose there are objections, means you have to clear within a period of 6 months from the date of filing the request. Okay, then the objections are met, the grant of patent is approved by the controller in a period of 1 month. So in a short, you are going to file a patent, right? So then it will be published in the journal within a period of 18 months. Suppose you want it published yearly, means then yearly request can be given. After that, within a period of 48 months from the date of filing the patent, you can ask for examination. Then the examiner will examine your idea and product. Then he will support a report to the controller of patents. In that report, if there are any objections, he will call you and ask for clarifications. If you are able to clarify it within a period of 6 months, you can take a time of 6 months, then it can be patent will be granted to you, right? If not, the patent will be abandoned. So this is a normal process for application, right? The certificate of patent is issued within 7 days. The grant of patent is published in the official journal. Okay, that's all. I hope I have briefly told you about how to file a patent. So you develop an idea, file a patent, publications, ask for examinership, and then finally, if there is no objections and all, the patents will be granted to you. This is what I want to convey to you. Thank you, friends. If at all you have any queries, you can ask me. If I know, I'll clarify immediately. If it is out of my reach, then I'll clarify it and let you come back to you later. Thank you, sir. Thank you, Professor Odivel.
Thank you, sir. Thank you for your wonderful speech, sir.
I assure that it would be a most important sessions we will be attending, sir. Happiness can't be far behind a grateful heart and a peaceful mind. I would like to invite Dr. Jayavardhan sir to convey his gratitude.
So thank you, Vivetika. Sir, really wonderful session, sir. So basically, our students having some idea, but they don't know how to file it and how to process it and all that. So your session will be really helpful to the students and also to the faculty members also. Since I am also a doctorate in our CSE department, I have filed 2 patents. That is early patent I have filed, sir.
I think I have told correctly. Am I right, sir?
Yes,
I have not deviated because I am not an expert. That is why. Out of my experience only, I am just telling. Yes, I have not gone for any training course. I have a certificate course. Nothing like that. Yes.
Yes, sir. So really, it was a wonderful session, sir. So on behalf of our Way and the College of Engineering for Women and our Innovation Council, so really we'd like to have such an eminent professor like you, sir, for today's guest. So thank you for your wonderful speech. Thank you, sir.
Thank you, sir. Thank you very much, sir. Thank you. Shall I sign out, sir?
Yes, sir. No issue, sir. We'll sign out.
Thank you, sir. Thank you.